What's being rolled out as a simple safety update sounds reasonable on the surface. That's how it's being sold. A tweak here, a review there, just making sure the roads are safe for everyone. But when you slow down and actually read what's coming in February 2026, especially for drivers age 65 and over, it becomes clear this isn't a minor adjustment. It's a fundamental rewrite of how senior driving rights are treated, and it's happening quietly, deliberately, and with very little public scrutiny. For decades, the standard was straightforward. If you could pass the same test, follow the same rules, and maintain a clean driving record, your age didn't matter. Experience mattered, history mattered, your actual behavior behind the wheel mattered. Now that standard is shifting. Under the new rules, age itself becomes a trigger. Not evidence, not violations, just age. Turning 65 now places drivers into a separate category where additional scrutiny isn't optional, and in many cases, it isn't even clearly defined. The most significant change is how medical disclosure and evaluation are being expanded. These rules give authorities broader power to demand health information, request physician input, and flag drivers for review based on conditions that may never have affected their ability to drive safely. And here's the critical part. The threshold for action is being lowered. A note, a concern, a routine checkup comment taken out of context. Suddenly, a license can be restricted, suspended, or placed under conditional status before the driver has a real chance to respond. This isn't about catching reckless drivers. Those laws already exist. This is about preemptive control. It allows decisions to be made not on what someone has done, but on what they might do. And once that door is opened, it's very hard to close. Because if potential risk becomes enough to justify restriction, then rights are no longer something you lose through action. They're something you keep only as long as the system allows. Testing authority is also being expanded, not just renewal tests, but surprise reevaluations, shortened renewal cycles, and discretionary road tests triggered by non-driving factors. That could be a clerical report, a third-party complaint, even an automated system flag. And when those flags appear, the burden flips. It's no longer the state proving you're unsafe. It's you proving that you're not. And let's be honest about what that means in real life. For many seniors, driving isn't a luxury. It's independence. It's access to groceries, medical care, family, work, and community. Remove or threaten that access, and the impact ripples outward immediately. Yet these rules treat that loss as administrative, not personal, as if taking away mobility is no different than updating a form. What makes this even more concerning is how little due process is built into the early stages. Suspensions can occur first, with appeals later. Restrictions can be imposed pending review. Temporary measures that don't feel temporary when weeks or months pass and life doesn't pause. And while the language emphasizes safety, it rarely acknowledges the cost of error. When the system gets it wrong, the damage has already been done. This isn't hypothetical. We've seen similar frameworks in other areas, policies that start narrow, targeted, and reasonable, then gradually expand. The definition of concern widens, the discretion grows. The exceptions multiply. And before long, what was once extraordinary becomes routine. Seniors aren't losing rights because they've failed. They're losing them because they've been reclassified. There's also a deeper issue here that goes beyond driving. It's the normalization of age-based governance. Once a group is officially labeled higher risk by default, the rules change. Protections weaken, oversight increases, and it becomes easier to justify interventions that would be unacceptable if applied universally. Today it's driving. Tomorrow it's something else tied to autonomy, access, or property. Supporters of these changes argue that they prevent accidents and save lives. Safety matters. No one disputes that. But safety achieved by assumption rather than evidence is not balance, it's control. True safety policy strengthens standards for everyone based on behavior, not identity. It improves infrastructure, enforcement, and education. It doesn't quietly move an entire population into a reduced rights category without a serious public conversation. What's happening here isn't loud. There's no dramatic announcement, no flashing warning. That's what makes it effective. By the time most people realize how much has changed, the rules will already be in force. Licenses will already be flagged, reviews already scheduled. And the question won't be whether this is fair, but whether it's reversible. February 2026 matters because it marks the moment when experience stopped being enough on its own, when age quietly became a liability, and when a right that millions relied on began shifting from something assumed to something conditional. And once that line is crossed, it rarely moves back. Once a license is suspended or restricted under these new rules, the story doesn't end at the driver's seat. That's the part too many people are missing, the loss of driving privileges. Now acts like the first domino in a chain of consequences that move fast and hit hard financially and legally. What used to be a temporary inconvenience is being transformed into a mechanism that can quietly strip away property, money, and stability without a traditional courtroom ever coming into play. Start with insurance. The moment a license is flagged, suspended, or placed under conditional status, insurance classifications change automatically. Premiums spike, policies are downgraded, and in some cases, coverage is canceled outright. For seniors on fixed incomes, that increase alone can make keeping a vehicle impossible. And once insurance lapses, the vehicle itself becomes a liability. Registration issues follow. Compliance deadlines pile up. Miss one step and suddenly penalties begin. Then come the fines and fees, reinstatement costs, medical evaluation fees, testing charges, administrative penalties that accumulate quickly and must be paid up front before any appeal is even considered. This is where the system quietly shifts from regulation to extraction. You're not being punished for an accident or a violation. You're paying to prove you still deserve what you already had. In many jurisdictions tied to these new frameworks, failure to comply fast enough triggers enforcement actions. Vehicles can be ordered off the road, some are impounded, others are surrendered voluntarily because the cost of compliance exceeds the value of the car itself. And once a vehicle is impounded, the clock starts ticking. Storage fees accrue daily, miss the retrieval window, and forfeiture becomes a real possibility, not because of criminal behavior, but because of administrative classification. That's why this moment matters legally. These rules lean on a growing body of precedent where administrative actions are allowed to produce financial loss without a traditional judicial process. No jury, no trial, limited hearings often after the fact. It's justified as efficiency, as safety, as necessity. But the result is the same. Property can be lost first and contested later. At all. This is what makes it a historic turning point. We are watching the line blur between public safety regulation and asset seizure, when the state can initiate a chain reaction that ends with the loss of property based on age-triggered review, not misconduct. The implications reach far beyond driving. It establishes a model. And model spread. What's especially troubling is how normalized this has become. The language is clean, technical, administrative. There's no mention of seizure in the early stages, yet the outcome can mirror exactly that. Assets are removed, value is transferred, and the individual is left navigating a system designed to move faster than they can respond. For seniors, the risk is amplified. Many don't have immediate legal representation. Many trust that compliance will lead to resolution. They follow the rules, submit paperwork, attend evaluations, pay fees, only to find the goalpost move again. Another form, another review, another delay. Meanwhile, the financial pressure mounts and choices narrow. And here's the broader concern. Once a framework like this proves effective, it rarely stays limited. Today, it's seniors and driving. Tomorrow, it's another category, another justification. The underlying principle becomes the same. Administrative determination first, property consequences second, due process later, or never. Supporters argue that no one is entitled to a driver's license or a vehicle. Technically, that's true, but that argument ignores reality. In practice, mobility is tied directly to economic survival, healthcare access, and personal autonomy. Taking it away sets off consequences that the law then treats as the individual's failure to manage, not the system's decision to intervene. This is why February 2026 isn't just a policy update. It's a legal signal. It tells regulators that expanded authority paired with limited oversight is acceptable. It tells insurance systems to automate penalties. It tells enforcement NCIs that property consequences are an appropriate extension of administrative rules. And it tells citizens that rights can erode quietly, not through dramatic rulings, but through layered procedures that feel too technical to challenge until it's too late. The most dangerous part is that this doesn't look like force. It looks like paperwork. And paperwork is easy to underestimate. But history shows that some of the most sweeping losses of rights don't arrive with headlines. They arrive with forms, deadlines, and fees that slowly push people out of compliance and into forfeiture. This isn't about opposing safety. It's about recognizing when safety becomes the justification for something much larger. When the cost of a policy isn't measured in accidents prevented, but in independence lost and property taken. When entire groups are exposed to financial risk not because of what they've done, but because of who they are classified to be. Once driving restrictions begin triggering asset loss as a routine consequence, the issue is no longer transportation. It's the balance of power between the individual and the administrative state, and February 2026 may be remembered as the moment that balance tipped.